Well, this bill was extremely important to get passed for an upgrade in the laws that we put together almost 12 years ago to allow for the opportunity to at least offer chances for mitigation for the potential to develop on low-grade wetlands in exchange for creating and enhancing more and better high-grade wetlands in the state. It's a win-win situation. You get a higher ratio of wetlands in return for development, and at the same time, we allow for old business parks and other designs that have been on the tables for years to continue to develop forward and not put at risk the wetlands, not put at risk our agriculture properties, and make sure that we have some opportunities at least to investigate and produce some mitigation for this enhancement and creation of more and better wetlands, but at the same time not stifling the economy, not stifling agriculture. I think it's a great win all the way around. Well, I think the misnomer has been that this is going to create some sort of a whole-scale filling in of wetlands. Again, we're talking about low-grade wetlands. There are no guarantees of getting a permit because in the end, the DNR is the final decision maker whether or not a wetland would be filled, and at the same time, they will still look to avoid, they will look to minimize before they even look to filling. And I think this is exactly what we promoted 12 years ago. This is exactly what the environmentalists and conservationists are asking for. It's in the bill, doesn't change. We make sure that the functional quality of those wetlands are not endangered either. And so again, this is nothing but a win-win situation for developers, agriculture, environmentalists, hunting and fishermen. It's a terrific bill. Well, we did have it in the original bill, but at that time it was all voluntary. Now if you're going into individualized permits, it is part of that permit process that you will look to produce a mitigation plan for consideration by the Department of Natural Resources. When we did the bill 12 years ago, we were breaking new ground. This is a scoping bill. We've had years to look at how the programs worked. We've decided that it needed a jump start, some freshening up, looking at what were the failings, what were the accomplishments, and how we could bring it into 2012 and beyond. And this is the product that we came out with, and as a result of so much work put in from all sides, again, environmentalists, sportsmen, developers, agriculture, fellow legislators, we came up with what we felt was a good consensus, a good approach to this bill and bring it into the current century. And again, it's a win-win all the way around. Because Wisconsin has a long and proud tradition of being able to regulate its wetlands. I've been involved with the program and environmental issues for 16 years here in the legislature. I was the original author of the bill. We brought in former players in this, Senator Coles, Senator Schultz. They were in on the original legislation, so we have a good working relationship not only between ourselves and the other House, but also with the Department of Natural Resources under both Republican and Democrat administrations. This is was our baby, and again, we're the ones that have been leading the rest of the nation. They're the ones that follow us. We don't need to follow them on this particular instance.